All right. If I kick off with introductions and things, then people can start joining as well before we get to the substance of things, perhaps. Right. If that's all right with you, Emily and Michael.
Yeah, that sounds fine.
Great. So our topic today, as you all know, is making and defending claims under a CAR policy. My name is Sarah McCann. I'm part of Chambers Construction and Insurance teams. And I'm going to talk to you along with Emily Hussain and Michael Levenstein, also a member of Chambers Construction Insurance teams. Please feel free in the normal way to put anything you like, within reason, in the chat function, questions or comments, and we'll do our best to try and monitor them as we go through and pick them up at the end. And we'll try and leave time at the end for any questions if you haven't all dozed off by then over your lunch as well. So at the outset, there are probably 2 points to note. The first is that there's an obvious overlap between considering making and defending claims under the CAR policy, because they're often mirror images, as you would expect, of the coin on the same issues. And the other thing is that above the many issues that are specific to CAR policies, when you're looking at making or defending a claim, you've obviously got to also have in mind the context of general insurance law. So you need to be aware of all the familiar issues about material non-disclosure, fair presentation, fraudulent exaggerated claims. The list goes on and on. In the context of 45 minutes, there's a limited amount we can do, but what we thought would be useful is if I'm going to give a very brief overview summary. Actually, this is on the first slide now, I think. I'm going to give a very brief overview summary of the typical nature and extent of cover under the policy. Because in making a claim, the key point is obviously to get your building blocks in place and understand your policy. Emily's then going to address some of the more procedural aspects, such as notification and dispute resolution. And then Michael will pick up on some points from the insurer's perspective, including, if we have time, on touching on the very interesting topic of inherent vice. So moving on then to the next slide. There are two defining features, as we know, of a CAR policy. There is no need for any fault to be established in order to enjoy the protection of the policy. And the insuring clause is not limited by reference to specific perils. So causation and responsibility are completely irrelevant. One might think that CAR policies are more straightforward than policies which only respond to specified perils. All risk policies respond to all risks, only they don't. It's correct that a CAR policy will respond regardless of the peril, but as we know, and anybody who's had any dealings with a CAR policy knows, large sections of most policies are taken up with exclusions. So in other words, everything is covered unless it's excluded. And in order to establish a claim, the loss must have occurred as a result of a risk, and there must be damage. So the policy will not respond to events which were inevitable, and that will link to what Michael will talk about on inherent vice. So you've got your policy, you pick it up, you're looking at it. What's the structure of it? Well, a construction project policy, which is also sometimes termed a CAR policy, normally contains three distinct sections. So you have the property or material damage section, the delay in startup section, and the third-party cover. Now, we're concentrating primarily on material damage cover today, although some of the things Emily will talk about will relate to all elements of the policy. And the policies usually share the same basic layout. You have your recitals and preamble, the schedule, which has the key information upon which the policy operates. So that will have your definition of the insured property, and the key financial information used in the calculation of the sum insured and the premium. Your operative or insuring clause, and we'll come on to look at that, a typical one in a moment, exclusions, then extensions. And then after that will come the general conditions, claims and notification clauses. And you should look at that, when you're looking at your policy, you should interpret it and look through it in that order. On that next slide, we've set out a typical insuring clause. Now, there's no single CAR policy wording, but this is a typical insuring clause. That says the insurer will indemnify the insured in respect of physical loss or damage to the insured property. Now that clause would then go on to say that property described in the schedule arising from any cause except as hereafter provided. And that neatly encapsulates the point that I've already made about all risks and exclusions. but it's the bit on the slide which is the gateway to the indemnity. That's satisfying those conditions is what gets you the money. The indemnity is for the benefit, as it says, of the insured. So we know it's a feature of CAR policies that they invariably include many parties as named insured. So your first step in making a claim is to check you come under that definition. But that's obviously not enough. You also have to have a sufficient insurable interest. So it won't work if you've completed all of the work, left site by the time of the relevant damage, the defects liability period for that work has expired. You won't have any insurable interest. And you need to be privy to the CAR policy, because even if you're a party named on it, you may not be privy to that policy if it wasn't intended for you to have the benefit of it. Physical loss or damage is one of the other highlighted elements of the Gateway Insuring Clause. As ever, what may appear to be a completely straightforward requirement has exercised the courts over many years, and I'm going to touch on the question of damage a little further in a moment. The insuring clause will also provide that the damage to the works must be during the period of cover, so it's important to check that too. I'm going to look very briefly over the next couple of slides now as to what is insured property. So insured property is primarily the contract works forming the substance of the construction enterprise in question. And that in turn is defined by reference to permanent works and temporary works. And they are a bit more like they are described on the tin. Permanent works is, as you'd expect, the structure that's envisaged, the envisaged outcome of the project and the materials supplied for incorporation in it. And the temporary works usually comprise structures and their materials that are required to facilitate the process. And those are things that can be removed from, or will be removed from the site on completion of the project. Some policies may also cover constructional or construction plant, and that will ordinarily relate to items that are not to form part of the works and will be reused on other projects. So for instance, things like scaffolding. On the next slide, I'm not going to dwell on this. I've just set out for you there things that are not generally covered under the CAR policies. Just pick out two of those in that list, perhaps. Professional indemnity. The liabilities of professionals working on a construction project that might arise out of the execution of their professional duties will usually be excluded. That would be the subject normally of their professional indemnity insurance. And latent defects. Any damage to the construction arising from latent defects that exist at the date of completion, but were not discoverable, or depending upon the wording of the policy, that were undiscoverable at the time of completion, are commonly excluded. So moving on then to the next slide, the indemnities for damage. Now, often the fact that there has been damage will be self-evident. Something falls on your car, something falls on your house. It's blindingly obvious there's been damage. Oh, were it that simple. One of the central and recurring problems and issues for claimants is distinguishing damage from defect in order to ascertain whether, as was said in the nuclear case, the damage was caused by a defect or was simply the defect itself. So what do we mean by damage? Turning to the next slide. Damage is the physical change in the condition of the property insured, which affects its value or use, and a defect is not damage unless the result is different to or incrementally greater than the defect. So unpacking that, it requires an adverse change in physical condition. So there needs to be an injury, there needs to be an occurrence, whereas by contrast, a defect is a condition, not an occurrence. Change in physical condition, what does that mean? Next slide. Well, the cases provide ample examples of how the courts have addressed the problem of what amounts to damage. I've set out for you on the slide some of the more well-known or interesting, in the loosest sense of the word, cases by way of some examples. I'm not going to go through them now, but they do give some assistance on what will amount to damage. One point that is worth noting perhaps is that the damage need not be permanent, and that comes out of the Ordula case. That's the last one on that slide. That the change in physical condition has to be adverse. Just two cases worth highlighting involving very different subject matter. The more cultured of you will instantly recognise that that's a Degas pastel painting on the first picture. And that's, of course, a reference to the Coram and Schramm case, where there was a submolecular change to the painting, which occurred because it'd been exposed to or close to a fire. And even though that was completely invisible to the eye, it was still held to be damaged because it increased the risk of future deterioration and shortened the life of the painting or pastel. And the second picture, the scallops picture, is of course a reference to the Raincar and Frigmobile case, where they were fit for immediate consumption, but they'd been raised to a temperature that shortened their shelf life. Every time I say that, I say shelf life, and that was held to be insured physical damage. Only two other points worth mentioning in the time frame that we have. First is that consequential deterioration in condition due to a defect can constitute damage. So we have the nuclear for an example of that. But where the line is to be drawn, as Lord Justice Ward said in that case, is a matter of fact and degree, which is always complete manner to a lawyer's ears, because that promotes work, because it's never easy. And the second point is that although contamination of the subject matter by another unwanted substance is capable of constituting damage, that won't be the case where it's intentionally combined as part of the manufacturing process. And there's the Bacardi Breezes case as an example authority for that. So you've looked at your insuring clause, you're satisfied that you fall within it. You then do need to, as we say, look to the exclusions to cover. I've listed some typical ones there on the slide for you. Just to pick out, professional advisors obviously fits with what I was saying earlier about this isn't a professional indemnity policy. Consequential loss, generally excluded, it's starting point. If it is going to be covered, it's only likely to be by way of an extension to cover, which might be very tightly worded. And defects. Now, it's common for material damage sections in the policy to contain an exclusion for defects. Insurers may be prepared to accept liability for some of those risks, and so the policies often adopt some of the standard DE clauses or leg defects clauses. We could spend a very happy day going through this suite of defects clauses. You'll be delighted to know that instead I'm not going to, but there is, as I understand it, a further seminar in this series that's going to focus solely on DE and LEG clauses. So, but the important point to know for present purposes, as per the next slide, is that we're talking here where you've already established damage in the first instance, and then you have the whole suite of the DE clauses. So looking then at, on the next slide, typical extensions to cover, that normally addresses the costs incurred by the insured in taking remedial steps to restore the insured property following loss or damage. And some of the common extensions are those that are set out there. And expediting expenses can be a useful one, as indeed can all of them if they're present. Moving on then to the next slide, the measure of indemnity. You've established that you've got a right to an indemnity. How much are you actually going to get? Well, a CAR policy is normally an unvalued policy. So where the policy identifies the insurer's maximum liability instead of an agreed value. And a typical insuring clause is likely to read as per the slide, X amount each occurrence, unlimited as to the number of occurrences during the period of insurance. Obviously it depends upon the term of the policy, wording of the policy, whether it's repair, reinstatement or diminution in value. I've just put betterment on there because betterment is one point worth noting. The general rule in an insurance policy that indemnifies the insured for repairing damage is that there'll be no deduction for any, even though the repaired structure may be superior to the original, unless the insured will be placed in a position of making a profit. So a lot of the time the tort law cases can be of assistance to that. It's not normally an issue because damage to the contract works normally occurs during the construction or shortly thereafter. So the repaired contract works are unlikely to be superior to the original works, but it could be relevant where, for instance, there's an extension covering, say, existing structures and existing buildings. And the final slide, point I want to mention, appreciating this is very skip through and high level of some of the points, is limitation. Because you can't be a claimant seeking to make a claim and not have an eye to how long you've got to make that claim. The easy point is that Section 5 prescribes a 6-year period within which the insured must bring any claim against the insurer. The harder point is when limitation starts to run, and that's on the occurrence of the insured peril. So we're back to difficult questions as to when was the date of damage. That can sometimes prompt some interesting arguments. And speaking of interesting arguments, I'm going to pass over now to Emily to look at some more of the procedural aspects to bringing your claim under the policy.
Thanks very much, Sarah. Probably more in hope than expectation there. I note that we have one question in the chat. I don't know if you'd like to address that now, or perhaps we'll save questions for the end. Sorry, Sarah, you're muted.
Sorry, is latent defect covered by the maintenance period? I think the answer is it completely depends upon what your period of your policy cover is. The answer is maybe, I think, is the answer to that one. But I'll give it a bit more thought while you're speaking, Emily, if need be.
Great, thank you. And so, as Sarah has said, I am going to be looking at the claims procedure from the defendant's, the insurer's perspective. And there is obviously a lot of overlap between making and defending a claim, and a lot of overarching principles which are applicable to more types of insurance than CAR. But I'm going to talk about some of the particular concerns for insurers prior to a claim being made, upon receipt of a claim or a notification, the obligations on the insured to notify the insurer of an event or occurrence, and particular features of notification clauses, as well as options for alternative dispute resolution, which may be contained in the policy. So there are 3 types of potential claim which can arise under a CAR policy. Firstly, a claim by the insured to the insurer for an indemnity for example, damage caused to the construction works or property by something such as a collapse, which would be the most straightforward form of claim you would expect to see. Secondly, there might be claims by the insured against a third party to recover losses which are covered by the CAR policy. This could include damage caused by a third party which nonetheless falls within the policy, either due to its particular terms or extension of the policy. Thirdly, potentially claims by third parties against the insured, where the policy expressly includes extensions to cover for example, public liability insurance or third-party liabilities of other kinds. Construction works are usually also covered by various different types of insurance, and those might include third-party and public liability, which might also form part of the same insurance contract. So you might find claims under a car policy which also arise as a result of personal injury or loss or damage to property suffered by a third party in relation to the construction works, if that's an extension that's been bolted on effectively. So moving on to the next slide, the insurer's position. Obviously, the insurer will have concerns under the policy to establish what its exposure may be, what are the risks of its potential exposure translating into a claim or an actual payment out. And in some cases, the insurer will be concerned to investigate or take control of an investigation or a settlement in respect of a claim in the place of the insured effectively, in order to minimize its losses and ensure that it has control of the process. So the default position under the CAR policy is that where damage occurs to the insured property, if there's an event or occurrence giving rise to loss, then the insurer's liability crystallizes at that point. As Sarah says, there's no issue of proving causation. Where there's damage that's occurred, it's all risks insurance, and that's what it's there for. So it is then for the insurer to show that the damage which underlies the claim either doesn't fall within the policy, or it falls within one of the applicable policy exclusions, or that the insurer has some other defence, such as fraud on the part of the insured or breach of a relevant warranty, which would excuse it from liability. So the burden is on the insurer to prove that the loss is excluded under the policy, and particular terms of the policy, where they're ambiguous, will be construed against the insurer according to the principle of contra pro forentum, in circumstances where it's the insurer who's drafted the policy and the policy is for the benefit of the insured. Possible defences, I list a couple here. If the period of insurance has expired, as Sarah said, potentially the construction has finished and the parties have walked away from the site. If the limitation period has expired, or if the claim isn't made by a proper party. Again, Sarah identified the parties that might make claims. These could be insureds, parties insured under the contract, who would also have to be intended to benefit from the contract. So I make the point there that a subcontractor who's agreed to obtain their own insurance, for example, could be precluded from making a claim where the CIR policy was not intended to benefit them because they have substitute insurance. Moving on to the next slide, the claims conditions and procedure. The policy itself will contain various conditions pursuant to which the claim should be made and to be satisfied in order to make a claim, such as taking particular steps in particular timeframes by the insured, giving notice, providing information, and this can be particularly important in circumstances where there could be a possible suspension or obviation of liability by the insurer due to some breach by the insured of a particular condition, if the condition is construed as a condition precedent to liability. I'm going to talk a bit more about that later. I refer to Section 10 of the Insurance Act 2015 in the slide, which relates to breaches of warranty which can be remedied, which don't increase the risks which the insurance is designed to protect against. The Insurance Act 2015 changed the effect of a breach of warranty on the insurer's liability to pay out under the policy in respect of certain conditions. A breach of warranty is capable of being remedied by the insured to restore the insurer's liability so that the breach doesn't automatically result in the discharge of the insurer's liability under the policy. The breach will effectively only discharge the insurer's liability for losses which are relevant to the risk the warranty was intended to mitigate, which is in order to avoid insurers relying on the breach of an entirely irrelevant warranty to avoid paying out under the policy. So, for example, this would prevent an insurer from relying on a broken alarm system to refuse a claim for storm damage. However, if the breach was in some way incidental to the actual occurrence of the damage, the warranty was aimed at preventing that risk, it might still excuse the insurer from liability. And under Section 11 of the 2015 Act, an insurer may not rely on a breach of a term that is entirely irrelevant to the risk under which the loss was caused. So if the insured can show that the non-compliance with the term could not have increased the risk of the loss which actually occurred in the circumstances in which it occurred, the insurer cannot rely on that breach to excuse liability. But if the breach could have contributed to the particular risk, or if it did contribute to the particular risk, even if the breach wasn't causative of the specific damage, then the insurer again could rely on that breach by the insured. So, for example, a breach of any term relating to a risk of fire will suspend cover in respect of fire damage, even if the breach isn't contributing to the specific loss which is claimed for. Moving on to the next slide, I'm going to talk about notification clauses. This is one of the key claims provisions, and it can be very significant because failure to comply with a notification clause can have serious consequences for the viability of the claim and the insurer's liability. The notification clause generally sets out the manner in which a claim must be notified and gives various key details as to the timing of notification and the content of notifications. I've put here a quotation from Lord Justice Potter in George Hunt Cranes Limited, in which he describes what an ideal notification should be. I won't read that out, but I'll give you a second to read it yourself. And then moving on to the next slide. Where compliance with the notification clause by the insured is a condition precedent of liability of the insurer, the failure to comply, as I say, can deprive the insured of cover entirely. A notification clause may not be construed as a condition precedent, and the effect of the clause or the categorization of the clause will be dependent on how it is construed by the court. Sometimes notification clauses are expressly said to be condition precedents within the policy themselves, which is, as ever, not a completely watertight way of rendering the clause a condition precedent, but it would definitely be unadvisable to treat it as though it weren't one in circumstances where the policy says it is, and advisable to comply with the entire notification clause if you were making a claim and defending one. So I quote here, I reference here AXA Insurance, which was a case in which the insured failed to notify the insurer at all of the claim against them before initiating proceedings. And this clause was found to be a condition precedent. And in this case, the judge described it as a complete defence to the insurer's liability. So although this wasn't the basis of the decision, you can see how it could be fatal to a claim. And so as an insurer, ensuring compliance with the notification clause is one way of ensuring that the claim is properly made. Moving on then to the next slide, the obligation on the insured under the notification clause entirely depends on its wording, and they can be pretty variable. They usually provide a period within which notification must be given, the form in which it should be given, to whom it should be given, by whom it should be given. They generally do provide a period within which the notification should be provided. Sometimes that's immediately or as soon as possible. That's quite common, understandably, in a construction context. It may also be within a reasonable period or within a specified period. The obligation on the insured is usually to notify the insurer of an event, occurrence, or circumstance which will or may or is likely to give rise to a claim. And here, may is construed as a fairly low bar. In the case of Europools PLC, the Court of Appeal construed wording whereby the insured was required to notify the insurer of circumstances which might reasonably be expected to produce a claim for which there may be liability under this insurance, holding that it was similar to a provision which refers to circumstances that set a deliberately undemanding test. So may is a deliberately undemanding test, which could probably be satisfied by a far broader range of circumstances than will or is likely. When the obligation is to notify circumstances or facts which might seem ambiguous in terms of risk, or which the insured might not consider are likely to give rise to a claim, and so they sit on the knowledge, this is one circumstance which might enable an insurer to say that notification was not properly made because it was not timorously made, or another possibility, notification may not have been given in relation to the correct issue if the problem is a developing one over time, which isn't sufficiently connected to a later claim. So the notification needs to be sufficiently connected to the ultimate subject of the claim, i.e. the same damage, the same issue, in order to proper notice. Moving on to the next slide, I've sort of started to talk about the matters which might need to be notified. Again, those will depend on the exact terms of the notification clause, and they might provide for the provision of specific information or multi-stage notification in the event of further developments, or to give further details after the initial notice is provided. The matters to be notified in a standard notification clause tend to be an event, physical damage, possibly latent damage or defects if covered, but that's non-standard in these policies, as Sarah has said, and possible claims by third parties. So if you receive, for example, notice from a third party that they're going to bring an adjudication against you, that may be something that you ought to notify your insurer. It probably is under the terms of your CR policy, depending on its terms. And obviously it's the knowledge of the insured which is necessary to make a notification, and it's that knowledge and the date of that knowledge which is usually relevant to the compliance with the clause. Moving on to the next slide, the question of how likely a claim needs to be in order to trigger the clause is a significant one. It's an objective test which is assessed in relation to all the circumstances and facts of the case. Again, it will depend on the particular wording of the clause and where the obligation is to notify of an occurrence or an event that's likely to give rise to an indemnity or a claim. This equates to more likely than not, so over 50%, however you work that out. Percentages are always interesting when you're giving prospects. And an obligation to notify in respect of an occurrence which may give rise to an indemnity has been defined as real as opposed to a fanciful risk of the underwriters having to indemnify. So examples might be clear cut, where there's damage which is evident in the construction but has occurred because a tree fell on it, for example, but it might be less clear cut if you receive, say, a notification from a third party making what appear to be ill-founded or spurious claims, and then the assessment there is for the insured as to determine objectively whether in all the circumstances there's a real risk to the insurer and whether or not the notification needs to be made. Moving on to the next slide. The content of the notice, again, this needs to be sufficient information for the insurer to know the claim it is that they're facing effectively, and is probably, again, prescribed by the wording of the policy. It could be a general notification, the hornet's nest referred to in the Kojima case, or it could be more specific. And moving briefly on to the next slide, timing of the notice. Usually notification clauses, as I've said, give timing, and I've set out some meanings of some commonly found time clauses: immediately or forthwith, within a specified time. This might be calendar days or with reference to a particular milestone, or as soon as possible. The last thing I'll say on this is that if no time limit is given in which the insured must notify, the courts will imply a term that it should be within a reasonable time, which again will be assessed objectively. Moving on to dispute resolution clauses, very briefly, these are commonly included in the policy and usually prescribe the steps the parties ought to take in relation to dispute resolution. I've set out on my final slide, which I will just canter through, some further obligations on the parties: a duty to investigate, to pay within a reasonable time, and the duty on the insured to act honestly. And I will hand over there to Michael. Thanks very much.
And my thanks to Emily. So we will be now going on a voyage of discovery on a medley of topics concerning other considerations to bear in mind, both legal, evidential, and tactical, when considering how best to advise your clients in respect of defending a claim. And Ashley, the next slide, please. And to this end, we need to understand the context in which we will be advising our clients in this brave new world. The insurance market, as almost all of us know, has seen a spike in the number of claims, especially in relation to business interruption. And yet, despite the government's willingness to adopt a hands-on policy in many areas of commerce, insurance has not been one of them. In fact, the extent of its intervention is broadly confined to an FCA guidance document entitled Insurance and COVID-19, Our Expectations of Firms, which outlines what it expects and advises insurance companies to do when dealing with customers, which by and large is to review claims on a case-by-case basis, and where necessary, to be flexible where policyholders were given reasonable expectations that coverage might continue. It does go one step further, which is to say that for insurance companies that were otherwise intending to suspend certain products, whether because it was no longer commercially viable or otherwise, that they need to consider the needs of their insureds carefully, especially when they are relying on renewal of cover to continue their business, and that they need to take into account any business-specific vulnerabilities, and that if they do not, it could be deemed unfair and that action voided by the appropriate ombudsman. Equally, consumers who are due to renew their policy should have the policy coverage and exclusions clearly explained to them in all the circumstances, and any exceptional cases or circumstances that they may be coming across need to be reviewed on a case-by-case basis by the insurer. And equally, even if a product was otherwise intended for suspension or being axed, then the insurers need not consider providing alternative products to their consumers if they wouldn't otherwise meet their commercial demands and are in their best interests. Not only should they not consider it, but there might be an express prohibition on them doing so if they are not fit for purpose. You'll see the second bullet point involving policy literalism. And by that, I mean that from personal experience, I will often advise insurer clients that they have grounds for declinature, which they blithely ignore, my advice that is, insofar as they say, well, it's just bad business and good practice to pay out even where we don't have to. I understand the commercial good sense about that, but in the COVID era in which we find ourselves, there is now a growing instinct on the part of insurers to actually grasp whatever legal bases for declinature that they can, especially considering the fear that many of them harbor regarding the opening of a floodgate of claims, especially where many of their insureds are facing very dire financial circumstances, which they don't want to lead to ruinous liabilities on their own balance sheets and reserves for, that is to say, the insurers. And I would say that there's usually a multifactorial approach where the policy does permit an insurer to decline cover, but they will nevertheless indemnify. And that set of factors often includes a combination of the amount of the claim, of course, the length of the business relationship between the parties, and the likelihood of the insured risk reoccurring. And also, it might seem too obvious to mention, but when advising clients, they need to be explicitly made aware, whether the insureds or the insurer, of what actually the scope of cover is. This is especially important in the context of CAR claims, because a lot of disputes which foment and ferment later down the road actually could have been dealt with very squarely initially in terms of pinpointing issues, some of which Sarah has already mentioned, involving distinctions, thorny distinctions between issues of design versus workmanship or damage, whether it's the works themselves, which are the subject matter of the policy, as opposed to third-party or pre-existing property, and understanding the precise delineation between the scope of the exclusions under the policy versus any write-back clauses which extend cover. So much like in an exam, it's always best to ask yourself before you put pen to paper or advice to client, what actually am I being asked to answer? What actually is the scope of cover before we begin fighting about it? Next slide, please. So once we clear that initial thicket of concerns out of the way, there are then more practical steps that the insurers can take to safeguard their position, and that, of course, the insureds need to be alive to. Reservation of rights, obtaining legal coverage on the scope of the policy, and the insured's own duties, which are enforceable by the insurer. So taking the first in turn. It's necessary to ensure that the insurers remain entitled to assert their rights under the policy, and this prevents an insured from subsequently arguing that anything said or done, for example, the instruction of solicitors to act on their behalf, or an insurer paying the legal costs initially, might give rise to an estoppel or a waiver of the insurer's rights. And insurers need to consider putting in place a reservation of rights at the earliest opportunity, and that includes even before contacting the insured in relation to the instruction and obtaining of the relevant papers or pre-action disclosure, which they will need to investigate the merits of the potential insurance claim, as well as to refresh that reservation of rights at every subsequent stage of the investigation of their own internal review of the claim or during the course of any litigation. And likewise, they are recommended to obtain legal advice, often by way of approaching counsel regarding the scope of cover, whether there have been any defects in notification, for example, as discussed by Emily, and of course, retaining privilege over the same. And it's not uncommon in fairly large disputes that I've come across where the insured as well will instruct their own legal team to advise on the scope of cover, and both parties will at least initially instruct their own solicitors firms where there is the possibility of later conflict. For example, the insured suspecting that the insurer may ultimately pull cover. And of course, no discussion of this topic would be complete without galloping through some of the duties we all know and presumably love now under the revamped Insurance Act of 2015, namely under Section 3, the insured's duty of the fair presentation of risk to disclose every material circumstance which it knows or ought to know, or alternatively providing sufficient information to put a prudent insurer on notice that it needs to make further inquiries. And as Emily mentioned, the format of that presentation of information needs to be accessible to a prudent insurer, in contrast to a hornet's nest or the equivalent of a Tesco carrier bag from a deranged client providing information in a chaotic format. And of course, it also needs to be provided in good faith and substantially correct. And failure to comply with those duties empowers an insurer with a panoply of remedies which extend well beyond just bog standard declinature to include proportionate reduction in coverage, which is a watershed change, as you're probably aware, following on from the Marine Insurance Act of 1906, which had previously set out the position. Lastly, I'd like to just briefly discuss the duty to cooperate. An insured usually has an explicit obligation under a policy to cooperate with an insurer's investigation of a claim. There was a 2006 Court of Appeal case called Shine, Dean, and Alldown, where the failure of an insured to provide information requested by its insurer led the insurer to legitimately decline cover. And of course, we wouldn't have job security if an alternative approach was taken in the later, albeit high court judgment in a case called Porter and Zurich in 2009. So 2 cases worth having on your radar. Next slide, please. I'd like to very briefly deal with the ambit of an insured's duty to investigate potential claims. As you'll see, there is no general duty on the part of an insurer to defend its assureds, but nevertheless, this is usually an express term of any insurance contract. Otherwise, it would be far less attractive to potential consumers. And where this provision is in place and is breached without good cause by an insurer, the insured, of course, has a right to sue its own insurer for failing to defend it against a claim. However, this needs to be counterbalanced by, again, Section 13A, which was inserted into the Insurance Act by the Enterprise Act in May of 2017, which allows an insurer a reasonable period of time to investigate and assess a claim before actually agreeing to defend or indemnify any of its insureds. And what a reasonable time to investigate and assess the claim in question will, of course, depend on all the relevant circumstances, which include the type of insurance in question, the size and complexity of the claim, and factors outside the insurer's control. COVID-19 is almost certainly going to be one of those such factors, but I cannot be more certain about that in circumstances where there has been an absolute dearth of case law on the appropriate interpretation of Section 13A, but nevertheless, something that you need to all be aware of. Equally, the insured's duty to investigate is buttressed by its also almost always having rights of subrogation and assignment, where upon investigating the merits of a claim, if it indemnifies the insured in the first instance and realizes that there are reasonably good prospects, it can seek recovery of its own indemnity from the third-party wrongdoer. Next slide, please. For those wondering why we have a rather distressed Joaquin Phoenix, this is a screenshot taken from the rather mediocre film adaptation of Inherent Vice from the eponymous Thomas Pynchon novel. It's scraping the bottom of the barrel to get any more uplifting photos in light of the topic. But this is a fairly self-contained and quite academically challenging area, which vexes the courts, but insurers like to roll out wherever possible in circumstances where it is not covered under policies because it is interpreted as effectively an intrinsic attribute of insured subject matter, which in terms of giving rise to loss, is loss which is almost always inevitable. And that analysis is taken from Lord Sumner in the 1921 Gaunt case, which I have on the slide, where he writes that there are limits to all risks insurance. And I quote, "There are risks and risks insured against. Accordingly, the expression does not cover inherent vice or mere wear and tear. It covers a risk, not a certainty. It is something which happens to the subject matter from without, not the natural behavior of that subject matter being what it is in the circumstances under which it is carried." And the Marine Insurance Act, which I previously mentioned, sets out at Section 55, subsection 2, that unless a policy provides otherwise, an insurer will not be liable for ordinary wear and tear, leakage and breakage, or inherent vice, because that is the nature of the subject matter which is insured. And that statutory definition was given authoritative interpretation by Lord Diplock in the 1983 Soya and White case, also on the slide, where Lord Diplock concluded that what that meant in the context of inherent vice was the risk of deterioration of goods shipped as a result of their natural behavior in the ordinary course of the contemplated voyage, without the intervention of any fortuitous external casualty, which was considered an essential requirement in the later Supreme Court judgment in 2011 of the Sendor Mopu, also on the slide. which concerned leg-breaking waves of an offshore rig, Soya and White concerning the release of trapped moisture within soybeans. But the key point being that if something is damaged or deteriorates because of an intrinsic attribute, then to a large extent, that loss or damage is inevitable. It arises because of inherent vice, and because that was effectively a certain outcome rather than a risk, it will not be covered under insurance. Save where there might be such a thing as an Inch Marie clause, where, for instance, latent defects, which manifest themselves, thereby becoming patent, might be under certain circumstances covered by policies. And you may recall we've previously looked at today leg and defects exclusion clauses, of which this was an early flavor dating back to the the Institute Time Clauses 1980s documentation, where they said that there was a need in the market for this. So Inch Marie clauses often come to the fore where there's a latent defect in machinery or equipment, which becomes patent. But this is to be contrasted, I must admit, a latent defect from ordinary wear and tear. But nevertheless, there is often argument and debate about the overlap between latent defect and inherent vice. And two instances where that was the case are the Leeds-Beckett judgment for Mr. Justice Colson, as he then was in 2017, and TKC London and Allios more recently. And very briefly, the Leeds-Beckett case involved a claim made concerning whether or not the university in question, which had a series of dormitories built on a former brewery site, which were suspended over an underground river, which caused sulfate attack and disintegration of the limestone and concrete foundations and eroded them until they became a mush, causing structural failure, was inevitable or not. And I can personally recall very impassioned, perhaps testy, argument about whether or not that amounted to inevitable loss or was something arising from an external fortuity such as a flood. And Mr. Justice Colson decided that there was no intervening accident or fortuity, but that the damage which occurred was inevitable. And that even if that isn't right, that the action of the water, because of its sulfate content, amounted to an example of inherent vice. I'm cognizant of time, so I'm going to skip over a detailed treatment of TKC and London, but please just be aware that inherent vice was considered there. Lastly, it's worth mentioning just some practical steps to be aware of when advising both insureds and insurers, namely that getting your experts and loss adjusters instructed at the earliest opportunity is key and advisable, both legally as well as commercially, both to keep costs down to a minimum, as well as to find common ground and define issues which aren't in dispute between the parties. But of course, you need to be careful about preemptively or inadvertently disclosing privileged reports, which are only for one party's eyes, even if they are in draft form. So please be aware of that. The timing of investigations and inspections of property ought to be made sooner rather than later before works are covered up. And there are any claims between insureds and insurers about delay causing needless expense involving opening up or additional remediation works. And penultimately, being judicious in which expert specialisms are actually relied on. On the one hand, Insurers want as much information as possible in order to assess their risk profile, but bear in mind that half a dozen different expert reports may not have permission granted to adduce in subsequent proceedings. And so the need for focus is advisable. And lastly, to continually monitor the legal and technical landscape involving coverage issues in considering how and when to make settlement offers, not only to keep costs down on the insurer side, but also to give the insurer an opportunity to pull cover if it so happens that a settlement offer on the table accepted by a claimant is rejected by the insured who wants to fight, thereby giving the insurer an opportunity to escape continued involvement in that claim. I fully appreciate the whistle-stop nature of that tour, but I understand that Emily and Sarah and I will be around for a little longer to maybe just flesh out some of these issues. But at this juncture, I'm going to catch my breath and hand the baton back to Sarah. Thank you.
Hi, can I start with saying thank you for sticking with us despite our overrun in time. It's much appreciated. It's always a bit hard to judge these things when you've got so much material to cover, but thank you very much for giving us that extra time. I think we've picked up on the first question in the chat orally at the beginning. There was then a question about whether if the insured knowingly does nothing about damage and it gets worse, that can operate to prevent an indemnity being given. I put an answer to that in the chat, but for my part, unless Emily or Michael have any different takes on it, I think the answer to that is likely it will depend upon whether there's one of the standard type clauses in the policy obliging the insured to take reasonable precautions to prevent loss and damage, in effect, a mitigation type clause, and they are standard. So, and if there, I don't think I've picked up on any other further questions from the chat. Please feel free, if you want to unmute yourself to ask a question, to do so, or put something in the chat.